Good morning, everyone, and welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is proposed amendments to privacy rules, important aspects, and future considerations. PYA is happy to present today's webinar on this important topic. You may submit questions during the webinar by typing a message into the questions pane of the control panel. Also, immediately following the end of the webinar, you'll be asked to complete a short survey and submit any additional questions. We'll respond to questions posed after the webinar via email. We've posted in the handouts pane of the control panel a PDF copy of the slides for your reference. Also, you'll receive an email later today with a copy of the slides and a recording of this webinar. With that, I'd like to introduce our presenter, Susan Thomas.
Thanks, Shannon, and hello, everybody. Wow, episode 49 of the Healthcare Regulatory Roundup. That's really amazing that we have put out all this really great information. So obviously, I'm not Kathy and I'm not Marty. So I'm filling in for them today, and we are going to talk about several of the updates to privacy rules in healthcare. So just a little bit about myself. So I am actually a consulting senior manager, and I'm out of our Kansas City office. So shout out to my Kansas and Missouri peeps for joining us here today. I've been with PYA for about 8 years, and my primary area of focus is in compliance and privacy regulatory management. So what are we going to talk about today? First, we're going to just, privacy and HIPAA pretty much are used synonymously, even though there are obviously some nuances to that. But we're going to do just a quick overview of the current HIPAA privacy rule. And then we're going to talk about why have so many updates been posted or proposed. And then we'll go into the 3 major proposed rule changes, 2 from OCR and 1 from ONC. And we'll spend quite a bit of time talking about what are in those proposed rules. And then we'll kind of wrap it all up and talk about future privacy considerations in light of all of these changes. So let's talk just a little bit about the HIPAA privacy rule. As you guys know, I'm sure you do, HIPAA was actually implemented in 1996. And it was a result of the Kennedy-Kassebaum Act. And a fun fact to keep in your trivia pocket, Senator Kassebaum was the senator from Kansas at the time, and she actually grew up in the same county that I did. So Nancy Kassebaum Baker now, but she and Senator Kennedy were responsible for pulling together the initial HIPAA rule that included privacy, security, and breach notification. So HIPAA, as you all know, stands for Health Information Portability and Accountability Act. So it was really fashioned initially to help with transmission of data, but also to keep the data that was being shared with different entities to keep it safe. So again, the 3 parts of the rule include privacy, security, and breach notification. The privacy rule standards came out in 2001, really focused on use and disclosure, minimum necessary, being able to define what protected health information is. Then the security rule came out in 2003, and it really set the standards for, keeping information confidential, keeping it safely stored, safely transmitted. And then in 2009, we had the breach notification guidance, which basically defined, how do we protect, how do we make sure that protected data, if it has been inappropriately used or disclosed, what do we do about it? What really constitutes a breach of privacy or security? And then, of course, we had HITECH in 2013. And so HITECH it's all about strengthening some of the sanctions associated with the privacy rule And it also brought business associates into the fray, keeping them as responsible to upholding privacy and security as covered entities. So again, the privacy rule, we're going to really focus on that part of HIPAA, and it establishes those national standards that are in place to protect highly sensitive information that healthcare providers are dealing with on a regular basis. So it really requires regulated entities to have safeguards in place for protection, but it also gives individuals a number of rights to their information. Oh, sorry. We'll go back here a little bit. Oh, we went way forward. Okay. So some of the key concepts that you are aware of when it comes to privacy is obviously use and disclosure, TPO, treatment payment operations, de-identified health information, permission versus authorization, minimum necessary, incidental disclosure, the opportunity to agree or object. A very important one, notice privacy practices, business associates, accounting of disclosures, and reportable breach. So when you think about the privacy rule, the current privacy rule, these are all the concepts that are part and parcel to it. So along with the standards and obligations that are in the privacy rule itself, OCR created an enforcement initiative in 2019 called the Patient Right to Access. And so this kind of strengthened, again, some of the patient's abilities to deal with their health information. It allowed them to, make sure that they could see or get copies of their PHI. They also allowed entities to charge a small fee for creating the requested records. And then in addition to monetary penalties and sanctions, the Right to Access Initiative implemented corrective action plans, similar to what you might see with a corporate integrity agreement. And as of March 31st of this year, there have been 43 settlements. So this means that the OCR is using this information and they are enforcing the patient right aspect of privacy. And just a couple cases that have been enforced recently. Life Hope Labs got a request from a personal representative to release her deceased father's records, and they failed to comply with that. So the individual made the request in July of 2021, and she did not receive the records until February of 2022. So this particular lab was fined about $17,000, and they were placed on a corrective action plan. So that's just an example of how OCR is utilizing this particular enforcement action. So let's talk a little bit about why are these proposed rule updates in process, what's important about them, and just kind of discuss the proposal part of a rule update. So moving right along. So again, just remember that the rules that we're talking about today are proposed rules. And as we know, working in regulatory compliance, the final rule might look the same, or it's very possible it will look very, very different. So just remember that these are proposed rules. You definitely need to be aware of them. Not necessary at this time to make a bunch of policy and form changes, but the awareness is going to be important. That way, if and when they become final, you won't be taken by surprise. So the first rule, proposed rule, came out in 2020, and this came out from OCR, the Office of Civil Rights. And they have a number of elements to their proposed rule, and we're going to go into detail in more detail about these. But basically, It supports the individual's engagement in their care. Hopefully, the proposed changes will remove barriers to care coordination and case management. And then supposedly it's going to reduce the regulatory burden on the healthcare industry. This rule was put out by Secretary Alex Azar in 2020, and his goal was really to make sure that patients had a way to get common sense coordinated care, and it would also help with value-based arrangements that were currently in the works. And then in 2023, in April of this year, the Office of the National Coordinator, ONC, introduced some proposed updates to information blocking. And so just when you thought you were kind of getting the gist of what information blocking was all about, they are proposing a few more changes to that particular rule. And these changes have been put into place to advance interoperability, improve transparency, and then just support just the sharing of data in electronic format. And then finally, the one that we're going to talk about, and this one has gotten quite a bit of attention recently, is also an April 2023 proposed privacy rule update, and it regards reproductive health care. So it really enhances protection for the patient and provider in reproductive health care situations. And reproductive health care, as we're going to talk about, doesn't just mean abortion. There's a number of other items that are included in the definition of reproductive health care. And then it prevents private medical records from being used in criminal or civil cases against the patient or the provider or the patient's representative. So let's, at this time, let's dig in a little bit more into the 2020 rule update. So there's some basic sections within the rule, and the first one that we want to discuss today is overhauling individual access rights. So these are some of the factors that are involved in this update. The first increase in individual rights is the express right to take notes, videos, and photos of PHI. And I know that kind of makes people cringe, especially my privacy folks out there. So this will definitely be somewhat of a change. A lot of organizations have a prohibition against any kind of videography. But remember, with this proposed rule, if this does come through, patients will have the ability to take videos or photos of their PHI, not necessarily of everything that's going on, but they will have that ability. And then it's the rule also proposes to decrease the time frame for providing PHI from 30 days, which is current, to 15 days. So that will also have an impact. And then just a prohibition on creating barriers to access. So, you know, you can't, if you have other means, you can't require an individual to come in person to either pick up the records or sign a release sheet. You have to make sure that there's not any unnecessary barriers in place. And then it also changes the right to direct the disclosure of PHI to a third party. So in this particular piece of the update, the individual can direct a healthcare provider to transmit ePHI to a third party, but it doesn't include other covered entities. So this particular rule update is targeted at healthcare providers. There we go. And then just kind of continuing on with the individual access, the definition of an electronic health record has been expanded. It's going to include, you know, a number of other resources such as educational information, adult student medical records, and possibly employment records. And then there's also a new definition for a personal health application. So these are going to be the apps that people might want to use to track different aspects of their health and their health care. So this will be something that, as we talk a little bit more about sharing data, that recognizing what those applications are and how to interface with them is going to be quite important. And then finally, the proposed rule, when it comes to access rights, talks about changing changes related to access fees. And this has always been something in the privacy rule that's been kind of subject to interpretation. So I feel like these changes are OCR's attempt to add a little bit more definition. So first of all, if a person comes in person to look at their records, you can't charge them for that access. And then again, the personal health application, if the individual is using that to request their records, there can be no charge for that. You can charge a reasonable cost-based fee to cover the expenses necessary to produce the records. And then you also need to post what your fees are going to be under the proposed rule. So this is kind of an exciting one for everyone, like let's say our front desk people. So with the notice of privacy practices, that's something that's very near and dear to all of our hearts. The proposed rule is actually, it has stated that it would eliminate the requirement for individuals to provide written acknowledgement of receipt of the notice of privacy practices. So that will, and that's part of that reduce the burden to healthcare entities. But it also is going to, the proposed rule is going to require some update in the notice of privacy practices contents. And these are pretty technical. It amends the header language, and then it also will require that you bring in statements on the individual rights. So in general, for this proposed rule, care coordination and care management, again, Secretary Azar was, that was really his overarching goal for the proposed rule. So it really talks, I think a really important piece of the care coordination and case management is that the proposed rule is going to permit covered entities to disclose PHI to social service agencies, community-based organizations, home and community-based service providers, and other similar third parties. And that is going to impact, you know, our release of information and who we are able to provide PHI to with permission and with authorization. So definitely going to require some process changes in considering the overall care management, case management and care coordination. And then also this proposed rule talks about replacing professional judgment, which is in the current rule, with good faith. And that's going to provide a standard for when you need to make a determination upon regarding the disclosure of information. It's based on good faith and in the patient's best interest. So the previous rule really talked about the professional judgment of the healthcare provider. So now, kind of with the expansion of the concept of care coordination and case management, they've kind of transitioned this determination standard, again, from professional judgment to good faith. And then another area that's in the proposal is related to telecommunication relay service providers. So right now, the TRS is really a public service, and it's available for free to allow individuals who might be either hearing impaired or vision limited to receive information related to their health care. So this proposed rule eliminates the need for a TRS provider organization to be a business associate, because they're really acting as a conduit. They're not doing anything on behalf of the covered entity, and they're not responsible for creating or storing protected health information. Okay, so now let's get into the this year's updates, and we'll start with the proposed changes for information blocking. And again, these come through by way of the Office of the National Coordinator. So really, with the information blocking rule, to start out with, there's some proposed technical changes. So this, with the information blocking rule that came out with the Cures Act in 2020, they decided to limit what would be considered electronic health information. And that limitation was defined by the data elements represented in the USCDI version 1 standard. So it didn't include all elements of a designated record set. However, in October of last year, the ONC adopted the definition of EHI. So that is the information that is impacted by the information blocking rule currently, and that will also be included in the final rule changes that come forward. So this change has technically already happened. It's, it was part of the timeline with the original information blocking requirements, but in October, the ONC just went ahead and carried through with implementing this particular change. So in regards to health IT companies and developers, this is another updated definition of what what a developer is, and it also clarifies what constitutes offering certified health IT. Now, individuals, folks on this webinar that work in healthcare industry, in provider organizations, if you're not developing health IT, these particular proposed rule changes won't be that impactful, but I think it's important for you to know because you are a consumer of health IT. So basically what offering means is that you have something for sale, you're going to resell it, you're going to license it, anything that's certified health IT. And then it's going to exclude like the subsidized and donated health IT that you might provide to providers, physicians, or other entities within your health network. And then it will also make available the production of APIs or online portals to be able to query electronic health information across an HIN or an HIE. And then it also provides some updates to the infeasibility exception. And if you remember, there are several exceptions to the information blocking rule. And basically the exceptions kind of fall in two categories. It's either, you're requested to fulfill a request and you don't do it for a number of reasons, or you just don't have the procedure or the process in place to fulfill a request. So the infeasibility exception, by definition, is the inability to fulfill a request for access, exchange, or use. And so what they have proposed to update it is to include some key conditions. So one of those would be uncontrollable events. Think of, natural disasters, some kind of, emergency situation within your organization, And then they also talk about infeasibility under circumstances. And this is where through a contemporaneous written record or other documentation, that it's consistent and non-discriminatory consideration. So the actor must be able to provide a written response to the requester to describe, why is this request to gain access to PHI infeasible. And then the proposed rules also add the new TEPCA manner condition. So TEPCA stands for the Trusted Exchange Framework and Common Agreement. And so the goal of this proposed change is to create this universal floor for interoperability all across the country. And gosh, how long have we been talking about this? With the advent of electronic health records, everybody thought, someday we're all just going to be able to, access a portal and see any information that we want to see. We're getting there, but we're not quite there. So this is all part of that, trying to mitigate, the burden that healthcare provider organizations have to go to fulfill requests. So if there is a agreement in place and with a qualified health information network, then the information will be readily available and easily shared. And right now, there are 3 qualified healthcare networks, and that includes the Commonwealth Health Alliance, the eHealth Exchange, and then, believe it or not, Epic has applied to become a qualified health information network. And so these networks will be able to, be in that position to expand their interoperability and increase the ability to share and release information. And then there's some additional technical changes to the certification program. I'm not going to go into all these because these are very technical. So just know that health IT developers, in order to get their products certified, they need to respond and be in compliance with the existing certification requirements, and then they also need to be aware of the proposed changes that are included in this rule. Okay, so now for the fun stuff. In April of this year, there has been a pretty important update to the privacy rule, and it has to do with reproductive health care. And this is an enforcement initiative and proposed rule update from the OCR. So the first part, and probably the most important part of this proposed update, is the definition of reproductive health care. So the proposed rule really provides kind of a broad brush to what reproductive health care means. They have defined it as care, services, or supplies related to the reproductive health of the individual. So again, you can see it's not just limited to abortion, but it covers quite a few other areas as well. So regardless of the individual's age or whether the care is pregnancy related, this definition of reproductive health care is going to include contraception, pregnancy-related health care, which includes miscarriage management, molar or ectopic pregnancy treatment, pregnancy termination, pregnancy screening, and products related to pregnancy and prenatal care. And as you can imagine, this broad definition is being considered just because of a lot of the current activity related to enforcing state laws related to abortion and abortion services. It also includes fertility or infertility related health care. And then the potential impact of this defined term is that most covered entities, and probably almost all covered entities, will be required to implement changes. It won't be just limited to OB/GYN or fertility related care. So this is really opening up how the privacy rule is going to be changed with this potential proposed rule. Excuse me. So let's talk just a little bit about how this came to be. So this privacy rule, the 2023 proposed privacy rule, its overarching goal, again, was to strengthen privacy protections for protected health information related to reproductive health care. Dobbs versus Jackson Women's Health Organization was truly a landmark decision. And it was the decision that was offered by the U.S. Supreme Court held that the U.S. Constitution does not confer a right to abortion. And so, basically this overturned Roe v. Wade and kind of set our country on its heels in multiple ways. So in response to that, President Biden issued an executive order. And the title of that executive order was Protecting Access to Reproductive Health Care Services. And this was in response to some threats and potential impact of state level prosecution and law enforcement actions related to the provision of reproductive health care. And as most of you are aware, there's been some pretty incredible and sensational headlines in the news regarding, women trying to receive care for some pretty dire situations. And the interpretation of the state law has been quite restrictive. So this executive order has set out to change some of that, have an impact to make reproductive health care less dangerous to administer. It also prohibits the use and disclosure of protected health information related to reproductive health care in certain criminal, civil, or administrative proceedings. So, if you have an individual who is requesting PHI in a certain situation, and the reason for the request is for some type of legal case, some sort of prosecution, there's some prohibitions on releasing that information. It also imposes a new attestation, a form that would be required for certain uses and disclosures of PHI, and we'll talk a little bit more about that. And then it's going to require changes to the Notice of Privacy Practices. And then it revises what the law enforcement exception is. So a number of significant changes with this executive order. So let's talk a little bit more about the use and restricted disclosure of this particular information. So the proposed privacy rule sets out to prohibit covered entities and business associates from identifying any person or disclosing this type of information for investigations and prosecutions of either covered entities or other persons trying to seek, obtain, or facilitate reproductive health care. As long as that reproductive health care is provided lawfully within the law of the state where it was provided, or if it is federally protected, required, or otherwise authorized. So this prohibition is a key part of the proposed rule, and it's going to be, it's a significant change, and it's going to require a lot of research and understanding to be able to, develop and implement processes and, most importantly, train almost everyone in the organization, what the changes are and how is the organization going to respond to them. In this, with this proposed change, the uses and disclosures of the reproductive health care related information would be prohibited even with an individual's authorization. And if you think about this one a little bit, you might have a situation where an individual who is seeking care or another person who maybe has facilitated reproductive health care, they are pressured to, sign a form, release some information. So this particular rule change would, guard against that and protect the information as reproductive health care related PHI. And there's no restrictions. The proposed rule has no restrictions for covered entities from making other currently permitted uses and disclosures, such as those for treatment, payment, and healthcare operations. So the original privacy rule related to use and disclosure for treatment, payment, and operations still stands. So you can share information with the billing company, with the insurance payer. A specialty physician can share information with primary care physicians. So those types of situations are still in place. Quality management, quality metrics, safety information, all that is still in place. So treatment payment operations will still stand with the proposed rule changes. And then it won't affect disclosures that are otherwise required for criminal or civil proceedings when they're unrelated to the prohibited purposes. So if you have someone who's seeking reproductive health care and they're involved in, a car crash or, some other type of situation that might bring forth criminal or legal activity, the information related to car crash can be disclosed. But if, at the same time, the same visit, they ended up needing some type of reproductive health care, referring back to the list that we just went through, you would be prohibited from sharing that information as it's unrelated to the car crash. And then covered entities will be required to carefully review requests, and this is where the training part is going to be very important, making sure that your staff has good understanding. They have some tools and some job aids to make sure that this process is followed appropriately. But it's going to be important to know, when can we release information to law enforcement, and when is it a restricted disclosure? So again, this is going to be a pretty impactful change that all covered entities are going to have to figure out how to develop and implement processes in response. So as I mentioned earlier, there is a new attestation requirement with this 2023 proposed rule. So the attestation is going to be put into place that would prohibit a covered entity from using or disclosing this type of information under the following privacy exceptions. So the covered entity would be prohibited from disclosing this information in a health oversight exception, judicial or administrative proceedings, law enforcement exception, and the exception for PHI regarding deceased individuals. So this is, again, another pretty impactful change when it comes to this proposed rule. So just an example of how that might play out. So let's say you have a request of records for 5 years of a patient's medical records. So the patient requested and received birth control at one point during that time frame. And the attestation, and then if you have an individual who is requesting information that's outside of TPO, you would need to obtain an attestation from that requester before the hospital or the covered entity can release that portion of the record. You can release any other information that is contained in that record as long as it's stipulated in the request for release, but you would need to have a specific attestation for releasing reproductive health care related data. And I don't know how many of you, your heads are spinning right now, but it, again, another really important change that's going to require some good understanding and new processes to be put into place. And then this particular rule is going to impact your notice of privacy practices. We talked about how the 2020 rule eliminated the need for written acknowledgement, but this is going to add some elements to, the proposed rule is going to add some elements to your existing notice of privacy practices. So you will definitely need to be able to update that document that you provide to patients. And it's going to need to be able to describe any of the restricted disclosures, and then also include in your notice of privacy practices the attestation requirement. So honestly, be thinking about that. Notice of privacy practices are, obviously a vital part of your privacy program. And it's going to be really important to make sure that those two elements are added to your notice of privacy practices. So there's also some modifications proposed for the standards of personal representatives. So this proposal is going to prohibit a covered entity from denying personal representative status to a person when the primary basis for denying that authority was the fact that the person facilitated or provided reproductive health care for that patient. So again, we need to be very cognizant of what is included in the definition of reproductive health care. And then you also need to make sure you understand how that applies to the different aspects of providing care. So if you have an individual who is providing reproductive health care or facilitating reproductive health care, that individual can meet the personal representative definition. And then also there are some changes to the information and interoperability considerations in the proposed rule. Obviously, as we've talked about, this set of updates is going to pose some practical challenges for everyone involved. You're going to have to be able to distinguish what is reproductive health care and what PHI is within that definition. Kind of not exactly, but a little bit like psychotherapy notes, somehow being able to mark that information within your medical record system so that it can be identified and segregated or released with appropriate documentation with the attestation. So definitely going to be some practical challenges in implementing that piece of identification of this really important information. So health information exchanges typically promote just an automatic exchange of information. Um, Again, this is going to require that there needs to be some type of review of information or segregation of information before that data is shared with on an HIE or disclosed in other means. So certified EHRs currently, they don't allow for this level of data segmentation. So want to encourage you all to put on your thinking caps and try to figure out what is going to be the best way to identify this information and make sure that it's not inadvertently released, especially when it comes to an HIE or an HIN. And it kind of feels like, I don't know about you, but it kind of feels like, you know, we have kind of conflicting goals going on here. So, you know, we talked about interoperability earlier and how, you know, there's just this big push to share information, you know, across the nation, making sure that every provider that needs PHI for patient care has that opportunity. But yet we bring in this particular piece of proposed rule changes, and it's really adding some restrictions and is going to impact the interoperability standards that are in place now, as well as those that have been proposed. So there's some definite important updates to the law enforcement exception in this proposed privacy rule. The administrative request portion of the law enforcement exception would only apply to requests that a covered entity is required by law to respond. So I don't know how many of you kind of battle with this, especially like in your emergency rooms or through you know, different types of litigation requests. But you should have a policy on it. Releasing information to law enforcement is permissible. It's not mandatory. So you need to figure out, you know, how are we going to filter, or not really filter, review requests from law enforcement and determine if their request really applies to reproductive health care. So that's going to mean that, you know, again, you're going to have to be able to review that. You're going to have to segregate some of that information. And kind of like with the car crash example, if a police officer comes in and wants, you know, information related to the cognitive ability of the individual, you know, were they under some type of substance influence or anything like that, you know, if in accordance with your policy, that release of information would be permissible. But again, if there was anything related to reproductive health care in that encounter or in the range of the record request, that would need to be carefully scrutinized. Again, it's going to probably increase some complications to making sure that covered entities are complying with the privacy rule, and just again making sure that there's good understanding, you know, who can we release information for, what kind of request form do we require? Are we requiring a subpoena, a court order, an investigative case number, whatever your policy is, just making sure that the information that is then released is carefully reviewed so that you're not violating any of the other proposed rule requirements for restricted disclosure. So with all that, obviously there are other rules and guidance that have been introduced that impact privacy. I really wanted to make sure I covered these three very important ones, very that have, you know, some significant changes that will be coming your way. And, we've talked a little bit here in the office about, with all of these changes kind of targeted at privacy right now, is there going to be some kind of, HIPAA mega rule coming out? It's, I don't know, it's possible. The 2020 rule has been talked about and discussed, and everybody's been waiting for that, implementation date, but hasn't happened yet. And then on its heels comes the 2023 privacy rule updates, as well as the information blocking rule updates. So, it's the federal government, so it's anybody's guess. And I think just having this information and making sure that you're aware of what's going on is going to be really important. In fact, my esteemed colleague Marty sent me a piece of information yesterday. And so, in addition to all this, there's also guidance related to tracking technology, which has an impact on privacy. And I chose not to include that today, but I did want to offer you this little tidbit that came from the American Hospital Association. And they are really urging OCR to consider, what do they consider, what should be included in the definition of tracking? What are the elements, the identifiable elements that need to be part of the tracking technology guidance? And one thing that they're really pushing for, according to this article, is about IP addresses. So with the guidance related to tracking technology, an IP address is considered a piece of identifiable information. And so the HA wrote, under the current guidance, an IP address is protected information, even if consumers are not actually seeking medical care. The same HIPAA protections apply if a consumer is searching for a physician or a medical device, seeking general health information about vaccines, flu, symptoms, or merely looking for information about visiting hours, location, address, cafeteria menus. So they're really kind of pushing to make sure that, we don't go overboard on some of our privacy guidance. So let's talk just for a few minutes about what the future holds. So as we look towards the future and we think about patient privacy, everyone should be aware that there's going to be an increased demand for virtual visits. So, COVID got everybody used to using telehealth. I used telehealth a couple times during COVID, and honestly, it was wonderful to be able to sit at home, talk to my provider, provide some patient monitoring data and things like that. And so a lot of people have gotten used to that, and obviously like the convenience and just the availability of that option. So there will continue to be just that demand to be able to utilize telemedicine. So patients will also want to know who's recording and monitoring their PHI, who can access it, and how it's going to be protected. So by means of using technology, there's always going to be some additional considerations. And then patients, honestly, by and large, do know that sharing PHI with other providers, with other covered entities that are involved in healthcare, can lead to better personal outcomes. So, if you have an individual who has certain medical situations, but they're maybe also seeing, someone for behavioral health, and being able to, maybe allow the two providers on both sides of that coin to see, what meds is this individual taking from the medical provider? What's the home environment like for this individual from behavioral health? How do those two interact, and how can we best achieve an optimal outcome? And then also confirming privacy for individuals might honestly become a brand enhancing mechanism. So it might show that if organizations can, market to their patients that they have, the highest security standards, that privacy is of utmost importance. This could be something to use for brand enhancements. And then new interoperability requirements will necessitate the collection and integration of more data across a bunch of different platforms. So again, that national wide, nirvana of sharing PHI is in the future somewhere, and we'll have to wait and see and participate in how that comes to be. And then just the patchwork of privacy standards. I don't know about you, if you're working in more than one state, it can just drive you crazy. So somehow we need to figure out how we're going to harmonize all that and make it work to the best interest of the patient. And what do we need to do about the difference in standards from state to state, federal to state, and so on. So those are all things that I foresee are going to be important when it comes to privacy in the future. So with that, I'm going to turn it back to Shannon. I know we may have gotten some questions throughout the webinar, and I will respond to each and every one of those and answer your question via email. So Shannon?
Susan, thank you and great job. Very informative. And like she said, later today, you'll receive an email with all our contact information and a recording of the webinar, and the slides and recordings for every episode of PYA's Healthcare Regulatory Roundup series are available on the Insights page at PYA's website, which is pyapc.com. While at our website, you can register for other PYA webinars and learn more about the full range of services offered by PYA. And please remember to stay on the line once this webinar disconnects to complete a short survey and post any questions you may have that you'd like Susan to answer. On behalf of PYA, thank you for joining us and have a great rest of your day.